Defending your assets, a high-stakes negotiation success story. Imagine being caught in the legal nightmare where everything you own is suddenly at risk. A court order mounting legal costs and a receiver ready to dismantle your entire business. Most people would see this as a hopeless situation. Today, I'll show you how our team turned what seemed total financial destruction into a story of strategic survival. Mr. B came to us in what seemed to be an impossible situation. The court had ordered Mr. B to pay his ex-wife £380,000 plus £1,500 per month until this debt was settled. On top of that, a court-appointed receiver was charging £40,000 plus VAT and costs. This situation was particularly complex because Mr. B had a partially constructed property that was 3/4 built, which he constructed himself. The receiver had been appointed to complete the works, sell the property, and hand over the sale proceeds to Mr. B's ex-wife. But it didn't stop there. They also had control of his shareholdings within 2 limited companies, his main company, and his subsidiary business. First, we conducted a comprehensive analysis of 3 key areas: Mr. B's personal financial situation, the true equity position of the property, and the financial status of both companies. We discovered something crucial. His subsidiary company had a secured charge against this property for a director's loan. This became a pivotal point in our negotiations. We meticulously documented the property's issues. Remember, this was a self-built property with its own unique challenges. Through detailed computations, we demonstrated that after settling the secured charge, there would be no dividends available from either of the companies. Initially, we proposed a £105,000 settlement. Despite having all of this evidence, the receiver spent 4 months conducting due diligences, all whilst their costs continued mounting. But we stood firm. We reached a settlement of £170,000 to cover everything, all costs and claims included. Consider this: the original claim had grown to over £500,000 including interest. On top of that, £45,000 plus VAT costs from the receiver. That's a saving of around £330,000. The stakes couldn't have been higher. Without our intervention, Mr. B, unfortunately, would have lost everything: his property, both companies, and everything that he built over the years. The outcome was bittersweet for Mr. B. Whilst frustrated at having to pay anything, he recognised this as an incredible result. He was cooperative throughout, though understandably had his ups and downs through this emotional journey. If you are facing a complex divorce settlement or a court order that threatens your business or assets, don't wait until a receiver is appointed. The earlier you get expert help, the more options you have. We've helped countless clients like Mr. B protect what they have built, and we can help you too. Contact us today for your confidential case review, and let's discuss how to protect your future and your assets.